Our next case is Hall versus Wooster. Each party will have 15 minutes to present their argument. Counsel, how long would you like to serve for rebuttal?
3 minutes, please.
All right, thank you. I will try to let you know about a minute of your time left. Just pay attention to that top circle. That's what's telling you is when you get to 3, that'll be your time, so it's counting down. Please don't pay attention to the bottom one, because I'm not going to reset that to 3 minutes, okay?
Very good, thank
Just
you.
look at your top time, and I'll try to give you about a heads up about a minute left.
Thank
And
you.
counsel, I'll try to do the same for you about a minute left, but you're in that middle circle if you want to look over there.
Understood, Your Honor. Thank you.
The arguments are being recorded, so when you come up today, please stay behind the podium and speak up loud enough so we can hear you, because we're visually and audio recording you. Also, please introduce yourself for the record when you do that as well. I don't know that it particularly is applicable in this case, but if you had a minor victim or child, please use initials rather than the term for that person. We read your briefs and ready to proceed whenever you are.
Thank you. May I please the court? My name is Carol Tran, and I represent the City of Wooster. The issue in today's case is whether the trial court erred in denying the city's motion for summary judgment in a trip and fall case where, first, the city had no duty to repair or warn regarding a crack in a crosswalk, and 2, the city is entitled to political subdivision immunity for which no exception applies. On April 10, 2021, around 4:00 p.m. in the afternoon, the plaintiff was standing at the northwest corner of the intersection of West Liberty Street and North Market Street. It was daylight out, the weather was clear. As she was crossing Liberty Street at this marked crosswalk, she tripped over this crack in the crosswalk and fell. As a threshold matter, the City of Wooster had no duty to repair this crack in the first place, which I will revisit during the second half of my argument. But even if it did have a duty, which it did not, the city is immune from liability. Political subdivisions, just like the City of Wooster, are entitled to general immunity for damages in a civil action for injury to a person allegedly caused by the act or omission of the political subdivision in connection with a governmental function. The Ohio Revised Code has categorized the maintenance and repair of roads and streets as a governmental function. Now, the city anticipates that the plaintiff will argue that there are 2 exceptions to this general immunity. However, neither of those exceptions apply. Taking the first potential exception, that is the exception for failure to keep a road in good repair or free from obstruction. In this case, the crack in the road did not require repair, and it was also not an obstruction.
Isn't that an issue of fact? I mean, you're holding up a picture, but we're at a preliminary stage, and there's probably some testimony about what was an obstruction, what it looked like, and isn't that an issue of material fact here?
I agree, there's disagreement on both sides of the table as to whether there was a repair or obstruction. However, I would submit to the court that it does not rise to the level of a material fact. In the case...
Because there's a picture? I mean, tell me why.
Certainly. In regards to the picture, there's also testimony as to the depth of the crack itself. Also, case law that's analyzed this sort of issue at the summary judgment stage. So, for example, in the case of Hecker versus Cook from the 6th District, they looked at what is considered a road requiring repair. In that case, they looked at whether there was a hole or crumbling pavement. So we have on one end of the spectrum a road that has holes or crumbling pavement. On the other end of the spectrum is the 2-inch rule, which is the rebuttable presumption that an elevation difference of 2 inches or less is considered insubstantial as a matter of law. And that's where this picture comes into play, because there's no dispute on either side of the table that this crack was 2 inches or less.
What about the obstruction part, though? Isn't there an argument that you couldn't get through there were lots of cones and you couldn't get through the...
Certainly. So, and that's one area that I want to touch upon, because I believe the court needs to separate out the area of the crosswalk versus the area of the sidewalk beyond the crosswalk. Where Ms. Hall fell in this case was at the crack in the crosswalk near the beginning of the crosswalk. Yes, there was construction at the end of the crosswalk where there was a sidewalk on the far intersection. That area was marked off by fences, by a fence. It was also marked off by large orange barrels. However, the definition of an obstruction, according to the Ohio Supreme Court in Howard versus Miami Township, is an obstacle that blocks or clogs the roadway and is not merely a thing or condition that hinders or impedes the use of the roadway or that may have the potential to do so. In this case, the fence was not in the crosswalk, the construction barrels were not in the crosswalk. Perhaps it was hindering or obstructing the use of the sidewalk, but I would submit to the court it was not obstructing the roadway where the crosswalk was located. Those are two separate locations.
Is that a disputed fact, that it was obstructing? Just the way you said it, is that Wooster's version, or is that everyone's version of how the intersection?
There's, from my understanding, there's no dispute that the fence and the orange construction barrels are located at the area of the sidewalk. My understanding, there's no dispute that the fence or construction was in any part of the crosswalk in the vicinity of where Ms. Hall actually fell. The hazard at issue, according to our understanding, is this crack. That's where she ended up tripping and falling.
And then part of our difficulty in reviewing this case is that the trial court makes no specific finding as to what its basis is for no summary judgment, for the exception statute for sound immunity. Are they saying it's obstruction? Are they saying it's not to repair? I can't tell that's a trial court decision. I have no idea what they find.
I would agree, and I think that's part of the challenge, that the decision below is quite brief and it does not go into the analysis regarding immunity or duty. However, the standard on review is de novo, so I believe these are issues that the court on appeal would have to review as if they were the trial court itself when analyzing this motion for summary
So
judgment.
you'd just be asking us to, in this case, overrule the court's decision. You're not saying we have a summary judgment motion out there, the court should have approved our motion. You're just saying the court should not have granted, or should not have denied our motion.
Correct. Our position is that the trial court erred in denying the motion for summary judgment, and we would ask that the court reverse that decision and grant summary judgment in the city's favor. The other exception that the city believes that the plaintiff may argue in this case is that there was a physical defect in the road. And the physical defect has been defined by Hamrick versus Bryan, a 6th district case, which states that it is a perceivable imperfection that diminishes the worth or utility of the object at issue. In this case, the utility or worth of a crosswalk is to facilitate pedestrians crossing the road. In this case, the crosswalk was still open for use and allowed a person to cross to the other side of the street. Living in Northeast Ohio, a reasonable pedestrian would anticipate that every crosswalk has some slight cracks or imperfections. A crack like this would not prevent a person from utilizing that crosswalk. But the city submits that the court does not need to engage in the immunity analysis to begin with because the city did not have a duty to repair or warn in the first place. The city is not the insurer of safety of anyone and everyone who decides to use its roads. And to show a duty to repair or warn, the plaintiff must show two things. First, that there was a hazard, and 2, that the city was on notice of the hazard. In this case, returning back to that 2-inch rule. This crack, there's no dispute that it was less than 2 inches in depth and therefore would be considered an insubstantial imperfection under the law. Coupled with the fact that there's no evidence in this case of any other trip and falls at the location of this crack aside from Ms. Hall before or after April 10 of 2021. But even if there was a duty, the open and obvious doctrine mitigates any duty that was owed by the city. During her deposition, Ms. Hall admitted that she would have seen this crack had she looked down at the road. In addition, there's been a lot of talk about this construction zone on the far side of the crosswalk that was closing off the sidewalk. In this case, there were 7 warnings that the sidewalk was closed. There were 6 bright orange construction barrels along with reflective tape. There's also a large chain link fence closing off the sidewalk. I would direct your honors to pages 15 to 17 of plaintiff's deposition transcript, in which Ms. Hall admits that she understood that these 7 warnings meant she could not access the sidewalk on the other side of Liberty Street.
But what about the other side? I mean, it was all chained up on each side?
The chain link fence circles around the intersection.
Just one part of the crosswalk?
Correct. Correct. So, in Ms. Hall's deposition, she states, let me back up with the question. The question was, in this photograph, can you see there's some orange barrels here? Answer, I see the barrels. Were those there the day you walked across the street? Yes. Was that fence up the day you walked across the street and fell? Yes. Could you see them? Yes. Was the sidewalk closed? Yes, because of the construction. Would you have been able to cross on the other corner onto Market Street? Didn't think to. But you could see from walking across the street that the sidewalk was closed, correct? Answer, yes. So in this case, Ms. Hall was aware that the sidewalk on the other side of the crosswalk was closed. To the extent there's any issue regarding whether the city was required to warn regarding the sidewalk closure.
How much of that comes in on this particular case? When our only question right now is, on appeal, is the sovereign immunity, do you have sovereign immunity or not? Anything else would have waited till the end of the case, we wouldn't have been able to be subject to appeal now. So how much of the other negligence type questions should we get into, other than the definition of sovereign immunity?
I think to the extent that,
You have about a minute left in your time, just so you know.
thank you, Your Honor. I think some analysis is required because in order to get to the issue of the immunity, there has to be an assumption that the city had a duty in the first place to warn or to repair the crack. If we don't even have a duty to repair or warn, we don't get to the immunity issue. So I think it's tied into the issue of immunity as a threshold matter.
Well, isn't immunity, the first part of immunity is that you're a governmental subdivision?
Correct.
Okay, so that is into the immunity analysis a bit, right?
Yes.
So I guess I want to follow up on Judge Stevenson's question about the issue in this case and what we have as an entry from the court, which of course the court speaks to. You don't have any concern about the entry that the court has spoken through here and how that works on appeal?
I believe there is a concern, given the lack of analysis. I believe that would present a concern for the appellate court.
But we do have case law that if we would affirm, and if there was a reason to affirm, that if we find a reason de novo, that it would stay affirmed, even if it's not the right analysis to get to summary, to not granting summary judgment. Do you know what I mean? And there's no prejudice. We have some case law that says that too. We don't necessarily need a full analysis from the court.
Correct.
You agree with that?
Yes, I do.
And you're in your rebuttal time now, counsel. You could keep talking, you could certainly wait for a moment.
Sure. So in conclusion, the city respectfully moves this court to reverse the trial court's decision and grant summary judgment in the city's favor.
I would like to ask you another question.
Yes.
You just said we don't need or in your conversation response to Judge Lansinger, we don't need a complete analysis. What does that mean to you, a complete analysis? What kind of analysis do we need from the court?
I believe some finding of fact or law would be required.
Thank you.
So some decision regarding whether immunity applies or does not apply, which I believe is absent from the decision below. Thank you.
Please.
Good morning, Your Honors. Attorney Dave Tadero representing Maribell Hall, the appellee. Your Honors, on April 15th, 15th, not April 12th, 2021, my client stood on the northwest corner of the square of Wooster, corner of Market Street and Liberty. She was on the northwest corner. She was heading south to pay her light bill at City News, which was south of that intersection. There were many businesses open, the bank, a hardware store, gift shop, restaurant, City News, where she pays her utility. Now, the city of Worcester wants you to believe that this case is simply about the tripping and falling on a crack in the crosswalk. Maribell Hall, a 63-year-old widow, believes it's something much greater. The city of Worcester has described this crack in the motion for summary judgment and the appellate briefs as a crack, thin crack, a minuscule crack. Maribell Hall believes the defect located on that crosswalk was much more significant than a mere crack. The defect is better described as a divot, a long divot that stretches across the width of the crosswalk. And it changes the elevation of that crosswalk suddenly by about 2 inches. And we asked this honorable court to review the photos.
But the appellate counsel said everyone agreed it wasn't 2 inches. So obviously you don't agree what the rise is in the crosswalk caused by the crack. Was it 2 inches or an inch?
It was 2 inches, and we measured it, and we have a photo that has a ruler in it, and it shows it's 2 inches. But this divot, this change of elevation goes all the way across the width of the crosswalk. It is not a mere crack or a mini crack. And that we would just ask that you review the photos carefully. Even more important than the defect in the crosswalk is Maribell Hall's argument that the city of Worcester created a dangerous and faulty condition on that crosswalk. The city of Worcester did so when they erected a chain link fence in the crosswalk on the southwest side. She starts on the northwest, heading southwest.
In the road or in the crosswalk?
The fence is in the road and the barrels are in the road. One barrel is in the crosswalk, the rest of the barrels are stretched all the way around the curve of that intersection, going east and west and north and south. All around that curve, the barrels are placed, orange barrels. One of them is in the crosswalk. On the
harm came so not from whatever was on the other side of the crosswalk. Her fall was caused by this, what you would say, negligent repair of the road.
I would say,
And not the obstruction over there, she fell because of this crosswalk, this negligent repair in the road.
no, Your Honor, I'm not saying that. I'm saying that that obstruction on the other side added to Maribell Hall attention being diverted. She was walking across that crosswalk because the traffic light changed in her favor. Also, the little box that says you have 20 seconds to get yourself across that walk, that was still functioning as normal, as if this was an open crosswalk, that everything was good and that there was a way onto the sidewalk. That wasn't the case here. She did not know that case, and quite honestly, it was disingenuous to read that testimony when there was clear testimony from Maribell Hall that, of course, after she got there and after she breaks her arm and she knows everything about the fence and the sidewalk is, yes, she answers that question as a point in time after it's all over. When in that deposition, when I ask her the questions, I have a few questions. I'd like to take you back to that time on April 15th. This was her testimony. Were there any signs on the corner that said pedestrians should not walk? No, no signs. Were there any signs on the fence that said no walking, no pedestrians to walk on this crosswalk? No. So back on that date, on April 15th, did you know that you could not walk through that area? No, there were no signs. But did you know you couldn't walk let me rephrase. Did you think back on April 15th of 2021 that you could not walk through that area? I thought I could, yes. When you were walking across, yes. And there was no signs, no pedestrians, no signs. There were no signs on the fence, no signs about the sidewalk being closed. That was her testimony. That clarified the testimony. And that was the same day, the same deposition. And honestly, that is not how this process should work. Because they knew it was a point in time, and they knew, taking her back to when she stood there, she understood that this was an open crosswalk, that she had a pathway to a sidewalk to all these open businesses, the bank, to City News, where she wanted to pay her light bill. So, there were no signs posted indicating the sidewalk was closed. To the contrary, the city continued to utilize the traffic walk signal box, that little box that says you have 20 seconds, which indicated to Maribell Hall that other pedestrians and other pedestrians that the crosswalk was open, and thereby indicating that the sidewalk was open and that there would be a safe pathway. And we have all crossed into construction areas where there's a fence, where there's open businesses, and we discover, yes, there's a pathway. Here, the city of Worcester erected this in the road, in the crosswalk, which is part of the road. And they put the barrel in part of the crosswalk, and they had, of course, other barrels, 6 or 7 other barrels listed, or positioned all along the street. Now, the city of Worcester is claiming immunity. In the question of immunity, the court must, of course, apply a 3-tier analysis. Well, Maribell Hall believes her case is an exception to immunity. Now, the exception in immunity is determined by RC 274402B3, where it states political subdivisions are liable for injury, death, loss to a person or property caused by the negligent failure to keep public roads in repair or other negligent failure to remove obstructions from the public roads. And that's what we have here. We have putting the fence up in the public road on the crosswalk and still leaving every other indicator that this is open and free to move forward. In Howard versus Miami, the court held that this particular revised code that relates to Tier 2, an obstruction must be an obstacle that blocks or clogs a roadway and not merely a thing or condition that hinders or impedes the use of the roadway or that may have potential to do so. Here, the city of Worcester created this obstruction. They erected the chain link fence on the southwest side of Liberty. The fence obstructed the crosswalk by blocking the pathway to the sidewalk, creating a faulty and dangerous condition. Can you imagine walking across, realizing 15 seconds after you move forward that you can't get through, even though the little box says you can, even though the light's to your favor, you can't get through. Now you're stuck in traffic, the light changes, and you're in no man's land. That's what she was concerned about. My client, Maribell Hall's attention was on other traffic coming from the other direction, and her concern also was on that box, on the light, on traffic, and on where's my pathway through this fence.
Well, the trial court's decision wasn't particularly clear, so is that what happened? Did she start going across and say, oh, I can't go across, I have to go back? Or when she started to go, she fell on the road because the crosswalk had, in your view, it was in disrepair, the crosswalk had the damage, and that's why she fell.
That's correct. In her attention, oh, I'm sorry.
No, that's okay. I want to make sure I understood what happened.
Yes, and her attention was diverted. Her attention was on all the other factors here. She even was asked under sworn testimony, did you look down and see the crack? She says no. The reason she didn't, like all of us, we have to maintain, be in control of where we're moving. But when you're moving through a crosswalk on, oh, by the way, the busiest intersection in Worcester, the square of Worcester, this is a place where, of course, a 63-year-old woman is going to be very concerned about traffic, the lights, and where is my pathway to these open businesses. The city of Worcester, I believe, should have posted a sign that said, this sidewalk is closed. They do it in other intersections when they're working on sidewalks, and they also have the ability, if they can't manipulate the little sign, they have, I don't want to say burlap, it's canvas sacks that they wrap over the sign so they don't give the false view or the false security that this is an open
But it
intersection.
seems to me you would be arguing if that obstruction wasn't there and she could have happily walked across the crosswalk.
Right.
You'd still be here today saying, look, this road was in disrepair and she fell and the city was responsible for not taking care of it.
Judge, I respectfully say I would not be here,
Okay.
and here's why. Because she's responsible for her movements in this world.
Okay.
Okay? And on sidewalks, which, by the way, was the majority in the motion for summary judgment, almost every case law they gave was sidewalk. This isn't a sidewalk. We were talking about cars going back and forth right in front of you. She would be responsible to step over that crack. I believe that if that obstruction wasn't in the road, in the crosswalk, and denying her a pathway, she still did not know that. She was looking intently on trying to find her pathway, and her testimony is clear in her testimony. It's a point in time, a distortion to ask somebody later if, well, it was closed, right? Yeah, it was closed. She knows it's closed a year later, but at that moment she did not, and it was clarified. In Taylor versus Cincinnati, the Ohio Supreme Court held the following: municipal corporations are not insurers of safety of their public highways or ways, and are liable only for negligence in creating faulty conditions in such a way or in failing to repair, remove, regard against defects or obstruction therein after actual or constructive notice of their existence. Well, they knew the fence was in the road. They knew that the box was working in the normal function, and it was indicating that you could walk through. They had actual notice. And if there's an argument that, oh, maybe they didn't actually know that this was dangerous, well, I contend that they should have known. I mean, the busiest intersection, and you're telling people with that sign, go ahead and walk through.
Don't we have a problem with kind of, I'll call it the bare bones nature of the trial court decision? We don't know why they denied summary judgment, whether they thought there was obstruction, whether they thought it was negligent, so we're stuck with, in our case, having to make that decision ourselves.
I think that is a problem. And the only claim that the city of Worcester has made is that they have immunity. And our Maribell Hall's position is, oh no, that immunity, the second tier, we qualify for that. That is an area that they made some mistakes on. I don't know why they use signs in other intersections, and I don't know why they use the SAC.
And you're down about 30 seconds of your time, keep answering the question number one. Keep going with your answer to the question, so
Okay.
your time.
Okay.
And I guess then, do you recall, we're going through sovereign immunity. They say, hey, we should get out because of, you should stay in because there's exceptions here. At the trial court level, did they say there were any defenses that once you got your exception, we have this defense that the court should have reviewed?
There was no defense.
They allege no exceptions in the, okay.
Right. There were no defenses listed, and since they put the claim in, We answered that claim with regard to the immunity exception that we believe we qualify for.
I see you're out of time. If you would briefly conclude.
Yes, I will. Thank you, Your Honor. Maribell Hall's attempt here is not to rewrite immunity laws in Ohio. We really are not here because of that. However, the facts here are unique with this fence and this box. The city of Wooster created these conditions that were faulty and dangerous, and they caused Maribell Hall's attention to be diverted away from what she was walking on. And because of that, it resulted in a trip and fall which broke her arm. Your Honors, I just ask that this court affirm the trial court's judgment entry dated February 12th, and thank you.
Thank you. You have a little more than 2 minutes left, counsel, for your rebuttal.
Thank you. May it please the court. During Appleby's argument, it was stated that the city created a dangerous condition when it erected a chain link fence and construction barrels at the edge of the crosswalk and sidewalk. And that this condition caused Ms. Hall's attention to be diverted as she was crossing the street. Your Honor, if we were to assume that to be true, that yes, the chain link fence and the construction barrels did divert Ms. Hall's attention as she was crossing the street, what this affects is the doctrine of attendant circumstances. Attendant circumstances are merely an exception to the open and obvious doctrine. It does not obviate Ms. Hall's duty to show that the city that there was a hazard and that the city was on notice of the hazard, but more importantly, whether immunity applies. There's nothing in the analysis regarding repair or obstruction under Ohio Revised Code 2744.02B3 that discusses attendant circumstances, discusses things such as fences or barrels. Rather, the discussion was the road in good repair, which that would confine the court's analysis to the area of the crosswalk where this two-inch change in elevation was located. As for the obstruction, I would again direct the court's attention back to the definition set forth by Howard by the Ohio Supreme Court, which is an obstacle that blocks or clogs the roadway. That crack did not block or clog the roadway. So again, the city respectfully submits that the trial court erred when it denied the city's motion for summary judgment and respectfully moves this court to reverse the trial court's decision and grant summary judgment in its favor. Thank you.
Thank you. And on behalf of the court, thank you both for your presentation this morning. The court will take the matter under advisement and issue a decision in due course.
Thank you.
When it's released, it will be mailed to you by the clerk of courts upon the day it's released, and of course, it will be the Ohio Supreme Court website.
Thank you.
Thank you.
Thank you.